into this discussion as a lawyer, and I recognize that when we're talking about reproductive justice, that the law is not the most important thing. But the law does have the power to erect barriers and to pave paths. So I think it's important for us to understand not just what the law is in Tennessee and how it got here, but also what's going on in other places and how that happens. Something that I did not fully apprehend until I was a law student myself is that law in the United States does not just get created in the state houses. It gets created in the courthouses too. So, what we've seen in Tennessee with the evolution of the fetal assault law as it currently stands was that really this is something that came from the prosecutors. It was the prosecutors using a fetal assault law in a way that it was not intended, in a way that it was clearly not intended by the language of the statute, and continuing to charge women with these crimes, ranging from simple assault all the way to aggravated assault, which carries 15 years in prison. And hoping that the legislature would deliver to them a stamp of approval, which they finally did in 2014. So that, in this case, it came from the legislature. In Alabama, which is a state that is doing very much the same thing, and in fact much more aggressively, the tool that they used was chemical endangerment of a child law. So that law was passed in 2006 to keep parents from bringing children into places where their children could come into contact with controlled substances, with the dangerous byproducts of methamphetamine production. As methamphetamine is not produced generally in Breaking Bad type labs, but it's produced in the homes of poor people. And so this law was intended to address that. And almost immediately afterwards, prosecutors started reasoning by analogy, essentially creating a new crime by analogy, saying that if a child is like a fetus, then the body of a pregnant person is like a dangerous location where the child can come into contact with controlled substances, essentially treating women as though they themselves were meth labs. And the prosecutors, this was something that they were proud of. This was their creative interpretation of the law, and they were going to use it to crack down on these bad moms. And in fact, the elected prosecutors of that state were running on a platform of who could lock up the most pregnant women and most new mothers. And the judges, too, who were elected, were running on a platform of who had the most punitive bail. Women were being held on $500,000 bail. We're talking about poor people in rural areas. $500,000, it may as well be $1 trillion. Are you kidding me? And they got their stamp of approval from the state's high court. Some of the cases, a few of the cases were litigated all the way up to the Supreme Court of Alabama, which said, yeah, if you look in the dictionary, we're going to cherry pick some dictionary definitions and see that the term child plainly, of course, means a fertilized egg. So essentially, anybody in the state of Alabama who uses a controlled substance, whether or not it is prescribed, whether or not it is a controlled substance that would have an impact on a developing embryo or fetus, is potentially subject to criminal prosecution under this chemical endangerment of a child law. Other states have tried to do the same thing. Most recently in Arkansas, a woman gave birth to a baby who tested positive for methamphetamine. He showed some symptoms at birth, but is now a healthy 3-year-old child. The only thing that is wrong in his life is that his mother has been incarcerated for 20 years. She was charged, actually a year after she gave birth, and after the state child welfare authorities had moved to reunite her with her child because they determined she was a fit parent and had made great progress in addressing her addiction. She was arrested and charged with a crime of introducing a controlled substance into the body of another. And you hear that title of the law and think, what in the world is that? And that's a law that was passed in the 80s in the wake of some notorious crimes in which there was a bartender in Little Rock who had been drugging women's drinks and sexually assaulting them. So they passed this law to prevent people from giving other people knockout drugs, from slipping drugs in their drink, from essentially forcibly drugging other people. But here, what the prosecutors argued was that Melissa McCann Arms introduce a controlled substance into the body of another when she gave birth to a child, because the way that the law works in Arkansas, it doesn't permit crimes against fetuses that include this particular law. So they're saying after she gave birth, but before the umbilical cord was cut, she was transferring that controlled substance. And that's a pretty cockamamie theory, but it's one that's been tried in many states. And it's one that has failed in many states. Even tough states like Florida, judges have looked at that law, that type of case, and said this law would not put a person of ordinary intelligence on notice that they could break the law by ingesting a controlled substance themselves. And as a matter of constitutional law, the laws that we write have to be able to be construed by a person, in order that they would know that what they're doing is breaking the law. And there's nothing in that law that says anything about placentas or umbilical cords or anything that would let you know that you might break the law by giving birth. So I want to step back a little bit and acknowledge that many of these cases are about women who use controlled substances. Many of these cases take place in the southern regions, but that is not exclusively the case. Another one that we worked on recently happened in New York, which is my current adopted home state, and I think that a lot of New Yorkers find it unbelievable. But in fact, there on Staten Island, which is actually the island on which I reside, and I had no idea that such a thing could happen there. A woman named Jennifer Jorgensen was 7.5 months pregnant when she got into a head-on collision with another vehicle. She hit the other vehicle, the 2 occupants of the other car were killed, and she was injured so badly that she had to be life-flighted out to the nearest hospital, where she gave birth to a premature baby by cesarean surgery. And unfortunately, her baby, because of prematurity, didn't survive. She was born alive but didn't survive. And again, a year after this incident, after her tragic loss, she was arrested and she was charged with 2 counts of manslaughter for the occupants of the other vehicle, and she was charged with a count of manslaughter for the baby that she lost. And in that case, the prosecutor argued, because there was a question as to whether or not she had been wearing a seatbelt, that she essentially was a bad mother to the child that she was carrying. In fact, the only thing that set her, what happened to her baby, apart from what happened to the occupants of the other vehicle, was that she wasn't wearing, potentially not wearing a seatbelt. So the jury delivered its verdict, acquitted on all counts related to reckless driving, on all counts related to driving with the influence of any sort of substances, acquitted in the deaths of the 2 other people. So, as a matter of law, now, a jury said she is not criminally responsible for any of those things, but she was convicted of manslaughter for the baby that she lost. And so she's essentially been in a fight to try to keep her out of prison for up to 9 years, away from the 2 children that she has, one of whom she gave birth to after this incident. And her fate really stands in the hands of the New York Court of Appeals, New York's High Court. And if that court rules against her, it has the power essentially to say that anything that someone who's pregnant does that could be construed as reckless, if she has a bad outcome after the baby is born, so if the baby is born alive and then dies, that can be treated as a homicide. And that doesn't just apply to substance use, that applies to anything. So delaying cesarean surgery, if you think of what could possibly be construed as reckless behavior, walking down an icy street, think of all the things that pregnant folks are told that they should and shouldn't do during pregnancy, and now any of those can be used by a prosecutor to say that this person was reckless. And the prosecutor, in her case, was particularly vicious in employing gender stereotypes to show that she was reckless. So there was a great deal of time spent on comparing Ms. Jorgensen's behavior, I guess the way that she presented in her emotional affect, to the occupant of the other vehicle. And the prosecutor said, look at this other woman who was dying herself and was telling first responders, please save my husband, do whatever you can, save my husband. And here, this other woman, she's concerned with her own injuries. What kind of pregnant woman wouldn't say don't, just save my baby, don't worry about me. She was concerned with her own injuries and her, her facial injuries. They made a big deal. She was concerned with her facial injuries. She had bitten through her tongue and was bleeding profusely. And so, yeah, she would be concerned about her facial injuries. Using that to say that essentially she was a bad mother before she even had a baby to be mothering. And I guess the last point I want to make about this is that when the state essentially can make those judgments of whether or not somebody is, acting appropriately as a parent before their child is even born, it creates opportunities for the state to step in and very invasively police the decisions that people make about their birth. So in one final case story, we had a client in Florida who wanted to have a vaginal delivery after 3 cesarean sections. And she had had some conflict with her medical care provider about this. And as Dr. Perry said, the admitted opinions rule, yeah. And so even though she didn't have any particular, anything that would specifically contraindicate a vaginal delivery after cesarean section, her physicians didn't want to treat her. And so they sent her a letter just days before her due date, telling her that if you don't consent to cesarean surgery, we're going to send out child services to your home. She hasn't given birth yet, so this is a threat against her custody of her other children that she has and the one that she's going to give birth to, right? So directly implicating her right to parent. We're going to institute a proceeding to force you to undergo the cesarean section, so like by legal process. And if you step foot in our hospital, we're going to do the surgery with or without your consent. This letter was signed by the hospital's CFO, which, in case you don't know, that stands for Chief Financial Officer. So that exposes a bit of the motivation there. And what ended up happening with her, she did not go back to the hospital. Yeah. So as anybody who's faced with a threat of violence would do, she sought a protective order. We went to federal court and asked the court to prevent the hospital from carrying out her threats, because essentially they were threatening her with a medical battery. And the court, in a very telling display of how little they understand the rights that are at stake when somebody is pregnant and giving birth, said, we're not going to issue that order because she doesn't have a right to force them to do a procedure that they don't want to do. So let me recap that. They have said, if you come into our hospital, we're going to do surgery with or without your consent. Right. And the judge is saying she doesn't have the right to make them do a procedure that they don't want to do. For anybody who's given birth, vaginal birth is not a procedure, right? She's asking them to not do a procedure on her, something which she has a human right, a constitutional right to do, to say, don't cut me. Giving birth to a healthy baby, she labored at home unattended, which is not what she wanted. She wanted medical supervision. Labored at home until it became unbearable, and then presented to a hospital where she voluntarily had a C-section, and fortunately was treated with respect. But this is only a qualified victory because nobody should have to labor at home unattended because they're worried that their human rights are going to be violated when they go to the hospital. So this is all to say that when the state can step in to protect fetuses by punishing, incarcerating, and subjecting to interrogations and child welfare interventions of pregnant people, this affects everybody who can become pregnant or elicit the outcome of their pregnancy.